Welcome everybody to the resumption of hearing stream 4, which is the hearing of submissions on the tangata whenua provisions of the proposed Central Baltic Bay District Plan. Before we resume the hearing, I will hand over to Pam Cooper for a karakia. Welcome, Pam.
Tau mai te mauri anoku. Tau mai te mauri atu. Tau mai te mauri whakaputa ki te whaiau, ki te ao marama, yei mauri ora.
And her worship, Alex Walker, will say a few words too. Thank you. Welcome.
Ina mana, ina reo rangatira mā tēnā koutou, tēnā tātou katoa, and welcome everybody back to our council whare, and a warm welcome to our mana whenua who are here in the room with us, who are on the Zoom screen with us and have participated in the process over the last few weeks. I just wanted to offer that welcome as we culminate this part of the process, which the district plan commissioning panel and reporting consultants have worked alongside our submitters on, and a valuable process which has allowed us to come back to the table, and our mana whenua in particular to come back to the table in a place where some strong conversations have been had about how to move forward, and in a way that has been respectful and empowering, and has allowed the key issues to be on the table and worked through. And I think that that leaves a way forward today, which is constructive and helpful, I hope, for you as the decision makers. So once again, a warm thank you to you for supporting this process, to our planners who have also supported the process, and a warm welcome to our mana whenua and associated parties who have submitted in these issues to take part in the hearing today. A very, very warm welcome. Nō reira, tēnā koutou, tēnā tātou katoa.
Thank you, everybody. Just a few matters I need to cover off before we commence the hearing. Firstly, it's the usual things about having phones on silent and all that lot. And then earthquakes under the table, hold and cover, and follow the staff if there is a fire alarm to the holding place where we go. We've got a schedule that will see us through to just after lunch today, but we may not need that time today. Firstly, we will hear from the reporting officers, Stella Morgan and Rowena McDonald, just to talk to their reports, the final reports, and to respond to any questions from the hearing panel. We are due then for a break, and then we have a number of submitters to see us through to lunchtime, and we propose to end up with any sort of final response from the reporting planners and journey at the moment around 1:30 today. That will allow the panel time to deliberate on previous hearings this afternoon and finalise this part of the district plan hearings. One other matter is we do have apologies from Dr. Roger Marker. He can't attend the panel, so hearing today, but he will still be there to respond to any questions the panel have around matters of tikanga. But he won't be obviously hearing or making deliberations on any substantial issues to do with the district plan because of his absence here. So thank you, Dr. Marker, for all your time and efforts to date. So I think in terms of the reporting panel, without any further ado, who are we talking? Stella, would you like to talk to your report, which we've all read, I will say, and thank you for the effort you've gone into that. So you can sit. You don't understand.
Morena, my name's Stella Anne Luoni Morgan, and I'm the reporting officer for the Section 32A report on the tangata whenua chapters of the PDP. And just to clarify, it's just me you're hearing from today. Rowena's here in support.
Okay, thank you.
As outlined in my report, I can confirm I've read the Code of Conduct for each of witnesses and the Environment Practice Note 2014 and have complied with it when preparing this report, and that I'm authorised to give this evidence on the council's behalf. to the proposed district plan hearings commissioner. So the parts of the district plan that are being addressed today and the submissions to it are found in part 1, introduction and general provisions. There's the mihi and the tangata whenua section. There's also part 2, district-wide matters, strategic direction, the tangata whenua chapter, and then 2 district-wide chapters, one being the sites and areas of significance to Māori chapter and the associated Schedule 3, and district-wide matter, the PKH chapter, Papakainga, Kaumatua housing and associated marae-based development. So that's the focus of my reports and response to the submissions on those. On the Commissioner's instructions, as set out in your minute 11, the hearings process for considering submissions on the tangata whenua provisions involved a 3-step process comprising a first hearing that was held on the 10th of August, and where I submitted a 42A report that didn't offer any recommendations, and submitters were invited to address their submissions and present their concerns and discuss these with the panel. Following that, there was a wānanga with submitters, which was held on the 5th and 6th of September, and that was facilitated by independent facilitator Dave Milner of Kahu Environmental and attended by tangata whenua submitters, the Mayor, council staff and myself as reporting. That resulted in a number of statements being produced and actions agreed to, and you've got a copy of that of Dave Milner's report being provided. And then the second hearing is the next part of the process, and my 42A report has included recommendations on the submission points and has taken into account the discussions and outcomes of the wānanga. Since issuing my Section 42A report in October, there has been additional revised wording on some sections of the plan, and it's amendments to Part 1, introduction and the general provisions tangata whenua have been circulated. I would just note that in that those provisions that have been circulated, there is an amendment on my recommendation in my report relating to I think it's Ngāti Keri's submission point on Ngā reo e te takiwā, the representative voices. It was brought to my attention that the wording proposed in there was not accurate, so I sought to change it. We haven't had any feedback as to whether that's correct or not. However, what I've done is taken a direct quote out of the submission on that point. So I'll just find that for you. So that's the tangata whenua, your page is headed tangata whenua mana whenua, and we go through to after the pepita. There's a section called Ngā reo o te takiwā, representative voices, and at the bottom of that is Ngāti Keri Hapu Authority. And so I put amended wording in there that says tangata whenua in the Paronga Hau Rohe. Stella August has raised that in her written statement that she's provided, saying that what was in my 42A officer's report was incorrect. So hopefully that responds to her point there. I've checked it with Pam Cooper, and she felt that that was more appropriate. But we haven't had any feedback from Ngāti Keri submitters on that, however. So just draw your attention to that. Other than that, I support the amendments that have come in from the various submitters and the work that's been done on that section of the plan. There are still a number of other unresolved, smaller unresolved matters, which I'll just highlight for you here. I'm still not clear on the use of the terms tangata whenua and mana whenua throughout the plan. However, I note that in the explanation that's been provided in the Te Ao Hurihuri section, again, this section that I've just been talking to you, it refers to, it states that the contemporary representation of tangata whenua is more specifically represented by the term mana whenua, those who exercise authority on the land which they occupy. While in essence, tangata whenua can literally translate the same concepts, tangata whenua has connotations to Māori and the homogenous Indigenous people of New Zealand. Mana whenua therefore specifies locality and in doing so determines rights to exercise authority in the eyes of the Crown. So this was provided by Darren Russell of Heretaunga Tamatea Settlement Trust, and no specific feedback was provided on that from other submitters. I'm unsure if that's a direction to use the term mana whenua throughout the plan, but note this matter was not resolved at the Wānanga. I do note that most submitters have used the term tangata whenua, and it was on Dr. Roger Marcus' advice that the term tangata whenua has generally been used in the district plan. I also note the National Planning Standards provide in Foundation Standard 1 mandatory direction clause 4 as follows. An appropriate term must be used wherever tangata whenua, mana whenua is shown in the planning standards. The appropriate term must be determined through engagement with affected groups and may vary depending on the context. If agreement on an appropriate term cannot be reached through engagement, local authorities must use the term tangata whenua. I also have had discussions with councils Po Whaituia and Cooper, and she can perhaps provide you with some additional advice on this. But her comment to me is that locally the term tangata whenua is what's used sort of on the ground, but you may wish to ask Pam about that as we go through the hearing today. The other matter that's outstanding, well, it's not really outstanding, but still in discussion is what sections of the plan or how the plan might integrate more te reo across the plan. And there are a number of sections seeking greater use of te reo in the PDP. I've used translations where these have been provided. And I note that the use of te reo in district plans has increasingly been adopted across the country. And some recent examples include Te Tai o Potini Plan, which is the West Coast, and Waimakariri District Plan, and the City of Naked Draft District Plan has incorporated it into headings and translations in some sections. So council will continue to work with tangata whenua on an approach to translation of the PDP, subject to council's budget and tangata whenua's capacity to assist in determining how best to do this. I also note that it is a council commitment in their Tūhono Mai, Tūhono Atu Māori engagement strategy, which has an action to increase the use and visibility of current and new Black language, and as well as the use of te reo Māori in its reports and publications. So there's definitely an intention there. However, you won't necessarily see it as it may finally look in the provisions that have come through to you today, or the plan in general. I also note in this section that's been circulated, that's been updated and agreed to by the tangata whenua submitters, that there hasn't really been a direction on the paragraphs following, immediately following the Pepeha table, which talks about individual section there that Darren Russell has suggested it's removed. I'm not sure whether it's after or before. That talks that there's a note about other hapu historically associated with the lands and districts of Tamatea. Those two paragraphs there, and the little table that identifies Waipokoro Community Marae. He has suggested that these are removed, but subject to further discussion from tangata whenua submitters. So there isn't kind of any final direction on that. So I'm just pointing that out to you. And there was also an action out of the Wānanga around revising the introduction provisions to the SASM chapter, and I think Stella has talked about that more in her submission points today. So perhaps I'll leave that to there, but we haven't received anything on that. So just moving to an overview of the provisions as traversed in my 42A reports for both hearing 1 and hearing 2. These provisions respond to Council's various RMA duties and have sought to implement the recommendations of the initial scoping report on the operative district plan that recommended a review of existing chapters to develop more comprehensive provisions to address tangata whenua values and issues, to improve protection for the sites of cultural significance tangata whenua, and to provide for papakainga and marae-based development. And that the latter is in particular gives effect to policies, policy statement. The proposed district plan has been prepared in accordance with the RMA and in particular the requirements of section 674 and 75. And the details of these are set out in full in my 42A report. There are also a number of higher order planning documents that provide direction and guidance for the preparation and content of a district plan. And again, these provisions have been detailed in the section 32 tangata whenua topic report. The proposed district plan approach, the preparation of these chapters has been guided by Dr. Roger Marker and Brian Gregory, who represented Te Tai Whenua Tamatea on the Council Working Party in the drafting stages of the district plan review. And as a result of detailed submissions from tangata whenua submitters and a thorough hearings process, these provisions have been further refined. So my 42A report is set out in 2 volumes. Volume 1 addresses submission points to tangata whenua provisions contained in part 1 and part 2, strategic direction chapters. And volume 2 addresses remaining submission points on the sites and areas of significance to Māori chapter and its associated schedule, and the EKH papakainga and Matua housing and associated marae-based development chapter. A number of associated definitions and the definitions and glossary sections are also considered. I've also started to prepare a table of all submissions, further submissions from tangata whenua submitters across the whole of the plan, and I'll provide this to commissioners in my right of reply, together with any amended recommendation as a result of today's hearings. So that's just to ensure that we've picked up on all those submissions that have come in across the plan from tangata whenua, and that we have considered all the matters that have been raised through this process. So that I will provide that table to you with my right of reply. Now turning to the specific section, the tangata whenua chapters, which is the part 1 and part 2. Of the district plan. So there were 90 original submission points and 67 further submission points received on these provisions, and they covered a broad range of issues, which I've separated into key issues. Key issue 1 addresses matters raised with respect to the PDP mihi, tangata whenua relationships, and Ngā Reo o Te Takiwā representative voices. Key issue 2 addresses matters on co-governance opportunities and iwi involvement in decision making. Key issue 3 addresses matters relating to requests to include the concept of te mana o te wai into the district plan. As the commissioners may recall, there were, I think, 3 submission points and associated further submission points relating to those provisions in the eco chapter, which we held over to this hearing. So they have been included in my report. Key issue 4 addresses matters raised in submissions received on the issue of development of Māori-owned land. Key issue 5 addresses the use of te reo in the district plan and specific submission points relating to terms identified in the glossary and definitions. And then the issues 6 to 10 in that report consider the remaining tangata whenua provisions that have not already been addressed under those above issues. With respect to sites and areas of significance to Māori, there were 9 submitters and 7 further submitters on these provisions, resulting in 53 original submission points and 81 further submission points. The majority of those submission points are in support or seek amendments, with 13 opposing, including seeking amendments. I've addressed submissions on those matters in key issues 11 to 15 of my volume 2 report, and they generally follow the outline of that chapter. So they deal with general matters, introduction, issues, objectives and policies, the rules, assessment matters, methods, reasons and results, and then the method of scheduling. With respect to the Papakāinga and Kaumatua housing and associated marae-based development chapter, there were 10 submitters and 3 further submitters on these provisions. That resulted in 28 original submission points, 6 further submission points. And of the 28 submission points, 27 are in support with the amendment and 1 in opposition. And again, my report follows the outline of the chapter in that. So key issue 16 deals with general matters, 17 deals with issues and policies, and key issue 18 deals with standards and remaining matters. I have read the evidence and statements submitted to the first hearing in August and have incorporated my response to the matters raised in those in my 42A report. That includes the evidence from Heretaunga Tamatea Settlement Trust by Stephen Dash, of Mitchell Dash, Nahapu Na Marae o Tamatea, Liz Monroe, Heritage New Zealand Pohiri Taonga, Kaianga Ora Homes and Communities, Fire and Emergency New Zealand, Kairako Lands Trust, Heretaunga Tamatea Settlement Trust, Federated Farmers, and Carl Tiffany. So I've responded to all those matters in my 42A report. I've also read the evidence and submitted statements that have come in for the second round of hearings from Fire and Emergency New Zealand, Heritage New Zealand, Pohiri Taonga, and Kaianga Ora Homes and Communities. I note the following, that Paul McGinsey on behalf of Fire and Emergency New Zealand is basically in support of the changes that we've proposed, which are consistent with what's been proposed for the zones. They do note that in their view it removes the flexibility that the standard has to provide for alternative methods. HNZPT generally support the recommendations outlined in my report and note the additional work that's required to update the SASM schedule. And Michael Campbell, on behalf of Kaianga Ora Homes, supports the proposed changes to policy 1 and 7 of my 42A report. Other than these matters, I do not have anything further to add at this point, but do anticipate returning to these in my formal note of reply. I'd just like to highlight the cross-plan matters that I will deal with in the table that I'll provide you in my right of reply. And in conclusion, I anticipate that you may have additional questions following the submitted presentation, and I will provide a formal written reply on these matters as directed by you when necessary, and I understand that our replies are to be provided to the hearings panel no later than 10 working days following adjournment of the hearing, unless otherwise directed.
Just a point of clarification before I turn to the panel for questions. This cross-plan matters schedule, it's just purely a schedule of where these matters have arisen, or the submitters have made points on cross-plan issues. It's not, there's no substantive evaluation or anything in it. It's just compendium of where these have been addressed by tangata whenua.
What I'll do is I'll provide you with that, but I will also have looked at all that. I'll tell you if I'll consider if I've made any changes to those recommendations as a result of stuff that's come in since those matters were heard. So for example, I think the main area, there's submissions that are not being considered today are like on the eco chapter, There's some in the earthworks chapter. There might be some in the subdivision chapter as well. So what I was wanting to do was just go back and check that that nothing, whether anything has changed. So whether I would change my recommendations given all the information we've had since those matters were addressed. So I will have, if I have changed them, I will give you an assessment. Okay, yes.
Okay, thank you. Any questions for you from the panel? He's looking at his right. Yeah.
I just had one question, and I think I just need clarification actually, just regarding the representative voices for Ngāti Keri. So just to clarify where I think it was 5.4.8 in your 42 report. I've lost it now. That wording has changed, and now you're going with is it? Is that it? Removing any mention of Kairaka?
Yes, that's right. Yes, yeah, that's right.
And it will deal with Stella August concerns.
Yeah, well, that would be helpful to confirm that with you.
And just one other thing, just the mihi. Oh, the other one was the wording that we've received in the Word document from the Tangata Whenua submitters. Has that been circulated through the submitters or yet to be?
So that has been back to the submitters. So it was drafted and then circulated to all those parties, and then changes have come back in, and we've made the changes as they've come back in, and then this has been made available. The final copy to where it is has been made available on Friday, I think, or this morning. There may still be, I don't know, it might be, Ham, you might be able to confirm with me with the pepeha, there might be still a few tweaks coming in on some of the wording for the pepeha.
But everybody's been given the opportunity.
Yes, it's been, well, I believe it's been pretty well circulated, yeah.
Right. When you start with paragraph 6.4.22 to 26. This is this discussion around being interested in this
Which paragraph?
sorry, 6.4.22 to 26. So it's about CWP1
Oh, yes,
and removing interested and or affected.
yes.
I guess I'm coming at it from a if there's no harm, why lose it sort of perspective, given I did take note of your commentary about the extent of the engagement prior to us getting the PDP and the involvement of Tangata Whenua. And I'm assuming somewhere in there somebody asked for interested as well as affected. So, and federated farmers aren't here, so you're getting the question. I just note that one of the reasons that federated farmers proposed to remove interested, as I read it at 6.3.14, was they say, while we support engagement of Tangata Whenua, like we support engagement with landowners, this policy does not provide much detail. Now, I guess my question is, can we really say, compare Tangata Whenua to landowners? Yes, they are landowners, but not all landowners have a treaty relationship. So I come back to interested or restricted, interested or affected. What harm is there in retaining it? I see the analysis of the benefit of taking it out, but what's the harm of keeping it?
Yeah. I probably have to think about that, but I think I think it was just. It can, not concern, but that not necessarily understanding where that interest had started and stopped, so that was more again the reason for removing it, but yeah, in terms of leaving it in there.
I'm just wondering.
I don't have a strong view either way, really. Yeah, but I do understand that. I guess it depends how that relationship or the partnership is structured going forwards. That will help define where those areas of interest are. But at the moment, we don't have that. So, without a formal partnership relationship in place, that interested is very wide and open. So
Equally, you could say that affected is very narrow.
Yeah.
And acknowledging your analysis in terms of going back to the acts and all of those sort of things, but your average person, the average Māori person, may acknowledge an interest, but are more likely to say, if they see the word affected, think that they have to be living next door. And so you contextually, if we're talking about promoting the environment, are we losing something by losing the word interested? No. So I come back to the question which you may want to think about: what is the harm in retaining it? And also, do you know of any other plans that have the word interested in it? Just off your, that was another thing I was sort of thinking about. Then I moved on to Manawatū. So 7.4.1. In volume 1. And I guess I wondered about whether we need to limit simply on the basis that not everything is certain right now in terms of what it means. Do we need to limit it? And I acknowledge that you've included for it in terms of the Hawke's Bay functions and the tiering one. I think it was written on it, the loss of mana or Kauai through modification. That is central. I wondered whether, because it's taking a sort of a loss perspective, but I wondered whether there wasn't an opportunity to acknowledge the potential for advancement at Manawatū. There's so much of what is Manawatū is about enhancement and improvement. And I wondered whether we could get something, a flavour of that somewhere in this, because at the moment we're talking about loss. So that was just something to think about as well. The next one I went on to was Māori land. And I was looking at 8.4.12 to 8.4.5. And so as I understand it in terms of 8.4.13, where you walk through that example. So you're saying that there is the benefit identified by the PKH is, as I understand it, of things, the controlled activity status. But as I read that in terms of your scenario, coming down to 15, where you say you've addressed all the has appropriately addressed opportunities for the development of Māori land. But doesn't in effect bundling mean that any benefit from the controlled status is lost through the process to get to non-compliant?
my understanding of bundling is you are then applying a non-conforming utility test, but you still consider the objectives and policies of the relevant chapters. So in that respect, the objectives and policies of the PKH chapter would be equally as important as, or have as much weight as the policies and objectives of the other chapters.
But we would still be looking at it through the lens of a non-complying.
It would be a non-complying activities in that specific situation where it was in a natural, where it was also in either of those other overlays.
I guess then that naturally comes down to 9.4.2126. So 21226. So it's about, again, about my land. It's back to this conversation we were having about the rules in terms of what would be applicable under the chapter, the PKH chapter, and what would. And I note that your reference to the MPS HPL. So just to be clear, you're not suggesting that we make any amendments. You're not asking us to align with the MPS HPL definition as opposed to the current rule. Not suggesting that.
I am suggesting that as an alternative, that would broaden it slightly, because I think that what the MPS HPL definition also covers that our existing definition doesn't cover is land that's, let me just check that. Land that's been returned to iwi or hapu that was transferred from the Crown, such as so the treaty settlement land, which may or may not be at the same, it may or may not fall within section 4 of the Te Ture Whenua Act. I'm not entirely sure, you might. Yeah, but I just thought that perhaps that was broadening it slightly. So so for example, I know that when you hear the rezoning matters later in the week, there's aspirations to develop land that's treaty settlement land around Lake Patuma and up on Pukeora, around that area. And I'm not sure whether they are also captured by that other definition. So
They be caught by land held under general title, wherever it is, where.
yeah, well, they may be. Yeah, that's right. They would be, but
Because I actually read it the opposite way. I looked at that and thought actually you're narrowing
okay.
the mechanism, because we've had evidence from yes in terms of land transferred, but there's not, and we've had evidence before us that that iwi have got these settlements. There's every chance that they'll buy land, so that won't be land that's transferred by the Crown or local authorities. So.
No, but that's another category in the rules, not part of the definition. Like general land is another category. It's not.
Yeah, so
The intention was not to narrow it anyway.
that was I was just trying to understand where we were going with this line, as distinct from the rules section in terms of land held under general title. I assume captured potentially. Then again, going on to 11.4.1, 11.4.11. And just so I can understand, it's about TW 13.
So in that comment at that paragraph, as notified relates to enabling Māori to better utilise ancestral land in ways that meet their aspirations. But as I read CWI3, the loss and alienation of ancestral lands is basically at the front saying this is what's happened. And then subsequently we've got further on to enable tangata whenua to use their land. It doesn't have to be ancestral land, it's just land. So on that basis, when you talk about enabling Māori to better use ancestral land, are we talking ancestral land or just the land? In that rule, because there is a difference.
And the issue,
Well, your comment in 11.4.11 is as notified, it relates to enabling Māori to better utilise their ancestral land. What I'm saying is my reading of it is this to use their land, not always ancestral land. And it sort of comes back to that point I was making, which was that tangata whenua with the settlement will probably want to utilise their land, and it may not be just ancestral land, it may be land that they choose to buy for the purposes of housing options, because we did actually have evidence before us that said our ancestral land is probably not useful for building on housing. It's not close to services and everything else. We would prefer potentially to buy land. And we want to ensure that these provisions actually cover that.
so I think the purpose of these provisions is we want to ensure that there is some link or some mechanism to ensure that that land, and that was the purpose of some of my changes later on, is that if you can establish that link and or that method for the land staying in Māori joint ownership in the future, then that's the kind of development that's envisaged. What we're trying to avoid is development of land happening that then could be on sold to general landowners and be then utilised not for reasons associated with ancestral land. That's what we're trying to avoid, that situation where you could have development happening and get on sold and it's no longer retained in Māori ownership. And then
How likely is it? I mean, we're talking about Māori that choose to put a papakainga development together. One of the comments we actually heard was that the issue, well, one of the issues of Māori land, and one of them called it a trap because people build, they develop, but they can't get any value from that. If we're going to promote the concept of home ownership with Māori, they have to have the ability at some point, if they need to move, that they can move. Otherwise, we're just locking them in. And equally, if you've got all your whanaunga around you, it's very unlikely that somebody from outside is going to want to buy into papakainga that's not whanaunga. So are we creating or thinking about an issue that is unlikely to arise in this instance? I just wonder if we are creating a concern where actually, when you think about it from a kaitiaki manaaki perspective, if we really choose to buy land closer to services, create a papakainga, convince their members to join. If we're saying, well, join, but you have all these limits and you're not going to be able to get the value out of the property if you want to move and you want to sell it, but you'll likely is not sell it to a relative because the relative is going to want to live within the framework of a papakainga. Are we creating an issue where there isn't potential?
I can only speak from the fact that my understanding is that these provisions have worked pretty well in Hastings.
And are we seeing a major influx of them selling their properties?
No, because they've got those provisions that are not, that prevent that from happening. And they have, yeah. So I can't really comment other than that.
I guess I'm contemplating that we will have ideas and we'll build their ideas. And part of one of the things they said in the wānanga at the end was, you know, to enable them to do things, utilising their assets, and wanting flexibility to develop the land. And I think if we're orgasming in a way that, you know, we could think of any multitude of reasons why we could do something one way and create more barriers than are actually needed, because the problem's probably not there. So again, yes, that question in my mind, and I'd be interested in your thoughts.
It doesn't stop it happening. It just means it's something that gets considered through the process and then how that can be managed. It's not a no, you can't do it.
Yeah, but we do have, for example, going back to that provision around the rule around general land. We are asking someone in council to determine whether this general land is ancestral land. Well, I hate that, but Māori all land is ancestral land. And then to ascertain why they're not converting it to Māori land. And Māori land, by its nature, provides all the protections that council are wanting because of the alienation provisions and things like that. But it may not be the preferred option by even Māori. It's generally not now. So I guess I'm saying, and trying not to create barriers, are we creating other barriers? And are we creating barriers for no reason? And then I had a final question, which was around, it's in the second volume, 2.21. All right, and it's around the 20% site coverage.
Oh, sorry, just. I'll just swap.
2.2.1. It's in the second volume, sorry, I had it up. One of our outcomes, and one of them was the 20% site coverage is restrictive. It was Carl Tipping of submission. I went through further on and I couldn't see where we'd gotten to on that point.
Which paragraph is it, sorry?
It's 2.2 Wānanga outcomes in the second volume. And it talks about the 20% site coverage.
Yeah.
I
I have addressed that. I have addressed that.
You show me, I just didn't. I didn't pick it up.
Okay, just have to wait before I find it.
Sorry.
No, that's okay. That will be in key issue 18, I think, which is on page 67. And I had suggested some amendments for that.
Just so I understand, 20% site coverage that you're talking about in terms of FH3.
Actually, I might just find it on where I can do a word search.
Yeah, that's what I've done. I got confused and went
I have addressed it and I have recommended a change. I'm just trying to find where I've got that.
It's on page 63.
Oh, so I did it in a general matter. Okay. That's what-
PKH6, PKHS3.
Yeah, that is it. Thank you.
So just so I understand.
Yeah.
Again, using the example of iwi by land, say in an area closer to services, but they want to have a papa kāinga. Would this 20% coverage apply if, say, any zone what they bought? So say they bought closer to town, would the 20% coverage still apply? Sorry, I mean, I just haven't read that, so I'm just checking.
So I think what I'm saying is for sites smaller than smaller sites that it wouldn't apply, but for larger sites it would. So I've landed on an area of 5,000 square meters. So anything under 5,000 square meters, and that was after looking at particularly at Parongaho, where they've got a lot of sections around there that are smaller parcels.
Yeah.
So I've suggested that we split that into two criteria. So if you're under 5,000 square meters, that maximum building coverage restriction wouldn't apply, but if you're over, it would.
So in terms of the over and in terms of the other zones.
Yeah.
Is that the same for everybody else? So what does everybody else have to do? So use the example.
So I guess it's different for different zones. So like this is where, so in the rural zone, this applies across all the zones, but predominantly it's in the rural zone that we've got these smaller parcels. So if you looked at the rural zone for building development, I don't think, is there such coverage for building development, but you're limited to only being able to build one house on 20 hectares. You've got other different limits. It's limited in different ways. So there's not a direct comparison.
Okay. So it's just making sure that there's an equity between, the family that has a plot that wants to build houses for their family.
Yeah.
Comparative to a papa kāinga. So you're comfortable that we've got that balance, right?
I think so. Yes, I hope so. Yeah. I think that does address those smaller parcels. The other constraints that they will have, there will be other constraints that will affect how much they can develop as well, such as hazards and like around Parongaho, there's flooding hazards, setbacks and other things that will also impact on how that looks. Our servicing is probably a constraint on the smaller ones as well. But I think by removing that, it just makes it clearer that we're acknowledging that there are smaller sites that may want to be developed for papa kāinga.
I think I'll stop there.
I think that, sorry, just to add to that, there's also those, Carl Tiffany also highlighted about the setbacks from roads and setback from neighbours, so I had to standardise those.
That's good. Thank you. Now that's all my questions.
Thank you. In your first report, just a couple of questions, really clarification on anything. In your first report in paragraph 5.4, page 19 on my version. All right. In paragraph 541, agreement to a technical edit prior to finalisation of decisions on the plan. Can you just lead me through how that, has that occurred, an agreement has occurred on it, or is that, how will it work?
So the details are still a little hazy. I might have to, Dylan, but what was talked about at the wānanga was that it would be good, once everything's kind of compiled, that there was, well, particularly for the tangata whenua provisions, that there would be an edit by a person that would read an agreed translator. And initially, Brian, Matua Brian's name was put forward. However, as he's also a submitter, there was potentially felt there might be a little bit of a conflict, but he has people that he can put forward. So that everyone was kind of happy with that, just to make sure that we get all the spelling, the macrons, the terms correct. So that process was pretty much agreed to. How it's going to happen or when it's going to happen, and we still haven't kind of worked out those details yet. But it would happen, I think it would happen post, once we had all the decisions together and we kind of had a final draft ready. would happen then. But prior to it being notified, would that be correct?
So it would be only really confined to editing, spelling, and capitalization
Yes,
issues. nothing-
yes.
Okay. And then the next, in para 544. This is what, just to again confirm, this is what was submitted the other day,
Yes.
right? Okay, that's the different version. There's quite a few places where you indicate that it'd be useful or helpful to the town if such and such submitter could provide feedback, and I suspect just looking through it, there's probably at the moment it's fairly limited feedback on that, but we can see that as we go progress through the hearing. Just picking up on the point that Commissioner Lovell said, now I'm turning to paragraph 7.4. 18, maybe, on page 36. And I'm just thinking that the district plan has a large role to play in subdivision and development, which itself can, as you can understand, create adverse effects on water quality and water quantity and things like that. And just to pick up on a point with Commissioner Lovell, whether that's not something that could be highlighted more in the district plan than it is at the moment. Notwithstanding that the regional council has such a large part to play in water management, but I'm just wondering, in your view, there's still scope to identify that.
I guess my thought on that, I don't disagree, but if you're in a reticulated area, you're going to connect to a network that already has a consent from the council. If you're in a rural area, you're going to need to get a consent from the regional council anyway. So it's kind of like just, I am slightly nervous about how far we go with referencing Te Mana Otiwai in the district plan, given that we don't have any guidance from the regional RPS at this point, and that at some point there will be a plan change to incorporate Te Mana Otiwai into the regional plan, and we may or may not then have to do a plan. Sorry, CHB may or may not then have to do a plan change to fit with that, because the district plan must give effect to it. So it's not that I don't think it's important. I absolutely acknowledge that it is. I just felt that the submissions that was those provisions that were sought by HTST were actually more regional plan policies. Particularly, there was one talking about water hydrological. I can't remember what it talked about, but there was some there that I just didn't think were district plan functions. And so I just don't want to get too far ahead in the district plan. I also think that at the Wānanga, there was a real, we kind of got to the end of the Wānanga and we still hadn't discussed Te Mana Otiwai, and there was a real nervousness around making any statements, although I believe a statement is being drafted about what Te Mana Otiwai means to Tamatea. But there was a real feeling that this is such a big conversation that hasn't happened yet, and there was a feeling of being pressured into having to respond to it. So I feel a little bit like that about the district plan as well, that we're kind of trying to make something fit that we don't really know what it looks like yet. So that's why I've tried to pop it in there and say we acknowledge it and it's important, but yeah, how that works out, we don't really know yet.
Okay.
I don't know if that's answered your question.
Yes, thank you. And just on the following page under the recommendations under 751, just a minor point, but I think it's the correction.
Oh, it should be accepted in part.
Yes. Okay.
Sorry, that is a correction.
Well, you've answered some of the questions I had that Commissioner Lovell put to you too, so. Yeah. So in volume 2, report number analysis in 2.4, page 5. Under 2.42 there, you said this will be presented as evidence prior to the hearing. So that again, just to confirm that that's what has been presented.
We haven't received any, and I think when you read Stella August's written statement that, yeah, they've had capacity and capability challenges of
I am trying to find it. There's a bit where you discuss it's a previous thing around adding extra quite a lot of extra words in regard to the principle of treaty of Waitangi. I've just been questioning over some of the wording on that, so oh, yes.
so that's in the very, very first.
Yeah, the first report, pages 54, 55.
Yes.
So on page 54, there's a whole new section around there about the Treaty of Waitangi, which and there's reference to kaitiakitanga in the sort of the middle bit there, and it says to have regard to it. I think that's should say a particular regard to it under section 7, isn't it? I mean, it's a minor point.
I'm just trying to find where it is.
It's a lone sentence that starts out, local authorities are also required.
Oh, to have particular regard to.
Yeah. That's it.
Yeah.
And another sort of wording question on the following page at the end of that shaded box. It talks about the treaty also includes the principles of it. Just technically speaking, it's a more technical question. It doesn't include the principles per se. The principles have come out from the application and case law and what have you around the treaty. Should have. Yeah. May need some time to think about the wording for that. Any questions from panel?
Just a final picking up point in terms of tomorrow for it's about earlier. In terms of clause 3.5 subsection 4 of NPSB. I'm just noting that there is an expectation that, at least in terms of the effects of urban development on the health and well-being of water bodies, etc., that there will be some sort of mechanism provided for in the district plan. And timing wise, under 4.1 of the NPSA, again, it does contemplate a serious risk. We're not inserting any of these points in effective of Te Mana Te Wai, which is the cornerstone of the NPSF. is in. I'm comfortable that we're actually meeting the requirements of that clause.
I mean, I have recommended having reference to it in there. It's not that it won't be in there at all. And I think one of the objectives, I just have to look. So it would apply as a consideration if you adopted my recommendation or a version of it. Let's find that chat there. That's as an issue, yeah, correct. So it says an issue, but not as an objective.
I'm just noting that it must include objectives, policies and methods in its district plan.
I think it's just a timing thing. Waiting for, yeah, as I said, I'm just anxious about doing that ahead of direction from the regional council. And without having a stronger understanding or sense of what it means locally.
Okay, don't have any further questions. Thank you very much. Just monitoring the time, we're running a little bit late, but those questions were necessary. So we'll take a break. How long were we scheduled for? 10 minutes, I think, before. Probably unlikely to do that. We've got 15 minutes. Would that be all right in terms of the next minutes? Stella? You know, Jessie? Yeah, so what are we now? So 10.
5 minutes.
Yeah, is she available to talk now? Okay. One issue, she doesn't mind being 5 minutes early, so works better. Are you all right, Stella? Welcome to the hearing.
Kia ora.
You all right? Are you okay to talk now? 5 minutes ahead of time?
Yep.
Feeling well enough? You're not too croaky?
Yeah, I'm a little bit croaky, sorry.
That's all right. That's all right. I'll just have, we've got your written statement here in front of us. Thank you. So I'll let you talk to it for us. Thank you.
Can you hear me okay?
Yeah, we're good. Right.
Okay, good. Well, morena. And yes, I'm here today again on behalf of the Kairaku Lands Trust. Sorry I can't be there today. And hopefully I'll be feeling better tomorrow, but if not, I'll be virtually again. And yeah, today I'm going to discuss the workshop and the wānanga process. The part 1 document that was sent around that Stella mentioned, and then some points from the 42 section 42 reports.
Thank you.
So the workshop wānanga process, yeah, I think I said this the last time. I felt that it was really valuable and a really important thing to be a part of, and I myself learnt a lot. And then, so when I read the report by Dave Milner, I agreed with most of the report. But I think he did admit that there was agreement by the participants there that having that wānanga should have been a part of the plan process prior to the formal part of the process, because it would have allowed us to as tangata whenua to share our ideas and thoughts, to get a better understanding of the issues, and maybe not, you know, just our view of the issues, how other people can view, have a different view of an issue. It would have allowed us to support each other a bit more, and and I think it would have allowed us to be more informed and allow us to participate better within this process. And so we would just like to see that the next time that this plan is reviewed, that happens earlier. 2.2 capacity and capability. Stella alluded to this earlier. This process has taken up a lot of my time, and as the years gone on, it's been increasingly harder to keep up with what's been required of me. I was a part of the working group to work on the SASM introduction, and I don't think anything was done. I think maybe Dean and Anne-Marie did some work on it, but I know that I didn't have any time to look at it. And a part of that struggle was when you are trying to represent not just your own views, when you're representing other people's views, and we're talking about tamatia here, you can't summarize and make those kind of statements without there being a group of you, and without, you know, like that kōrero that happens when there's a group of you, and that sharing of ideas. So for me, not being together as a rōpū, as a group, as a working group, meant I was really apprehensive about doing that. So yeah, I do think there should have been more support administratively to get together. And, you know, I mean, I hate to say it, but financially, people would make themselves available to do that if they were getting paid for it. Yeah, that's just a fact. Page 2. The tangata whenua, mana whenua section. An amended version of this was sent to the Wānanga participants on the 2nd of November by Pam, and feedback was requested. And then what's in here is the points that I sent in an email reply on the 3rd of November. There's the marae pepeha for kairako. I just want to note that the tohu toa are important, and I understand that Jill Munro has been in contact, I think, with Pam Cooper regarding the pepeha for paurere. If council haven't received that, then I can get that for council. I do want to mention the definition of mana whenua and tangata whenua. Again, this is like a hard one, and I think in some ways it can be personal, your own personal view on the difference. I use both terms, and half the time it's subconscious which one I'm using, but for me, I am talking about our land that has always been ours, and that, you know, we still have, that we still occupy, that we still use. I refer to myself as tangata whenua. So of that land that was my ancestors, that we still have, that we still occupy, that has been passed down through the generations. Mana whenua, I will tend to use when I'm referring to land where we don't own it so much anymore, but we still have an interest. So the pā at Kairako is a really good example. We have authority and dominion because that pā was our pā. We have history associated with that pā and that land. So I don't know if that's helpful, but that's how I clarify it in my head. Can you just excuse me while I turn around and blow my nose?
Put you on mute.
Sorry.
Right.
Page 3. And this 3.31, there is a reference on the first page of that tangata whenua document that was emailed that mentioned that Central Hawke's Bay was first settled by the ancestors of the New Zealand Māori in the 9th century. And this is not the current thinking in the archaeological world. The earliest evidence points to the settlement of New Zealand in the mid-13th century, so from 1250 to 1280, and it occurred throughout the country. So no place was settled earlier than any other. They believe that it was a migrant strategy to distribute as many settlers as they could around the country, and they were all connected. They stayed connected to share resources and knowledge and information and survival techniques, I suppose. So yeah, I think that should be amended. And then Stella mentioned earlier about the Ngā Reo o Te Takiwā section, and that's been amended, so that's great. The volume 1, key issue 2, co-governance and iwi involvement in decision making and cultural impact assessments. Page 30.6.4.35. The report mentions council may be required to make a judgment call or assess on a case-by-case basis how cultural sites and cultural values may be affected by development, and refers to the SASM schedule. Again, our concern comes from the fact that many sites are not recorded and the schedule does not have many sites listed. We think this concern is addressed, or this concern is addressed by the amended SASM, is it policy 4? But yeah, if that could be clarified, that would be good. Page 79.14 for 21. The report asks for some guidance from us about the amendment, and just we're happy with that amendment. page 4, this is the second volume, page 16.3.411. And again, the report asks for or mentions that we didn't provide any alternative wording, so I've made an attempt. Protection of site values in areas of cultural and spiritual significance to tangata whenua requires working with tangata whenua who hold this information and knowledge. It will involve establishing meaningful relationships, information sharing and education about the Māori history of Tamatea, Central Hawke's Bay, to understand the value we place on our sites with a shared objective of achieving site protection. So there were a couple of other points that I've made just from listening this morning. One of the things was about something that Loretta mentioned. I do believe there is a difference between ancestral Māori land and land owned by Māori. And it doesn't really matter if it's general title or Māori freehold title. We have been through treaty settlements. There is the likelihood that Māori will buy land that's either Māori freehold or general title. And I know that some big trusts are doing it, and they they are buying back land that was historically theirs. But I think that land is different to land that has been retained by Māori throughout time, because that connection and that association hasn't been lost. There's also a struggle that's associated with retaining that land and loss that people have had to endure. Sorry. I don't think that that can be represented in a district plan, but the district plan does need to allow for Māori to do or have that ability to do on ancestral land what really is their right to do on that land, because it's different land, in my mind anyway. And yeah, I noted down some words that Loretta mentioned, and the key: enable and develop and utilize. Those are words that we need to be able to do on our land. And this relates a lot to what I have to say at tomorrow's hearing. And then the other point was just about te mana o te wai, and Stella mentioned that she expects that council will need to do a plan change once that comes into effect. And I would like to know, is council expecting to do that with the National Policy Statement for Indigenous Biodiversity as well? Because I feel that further consultation is required for that as well. And that's all that I've got to say. And I'm happy to take questions.
Thank you very much, Stella. Thank you. I've just before I turn to the other commissioners, just a quick clarification issue. The pepeha that you have provided in your statement, in terms of the wording for Karako, is different to that was circulated the other day. I'm just curious as to know why and which pepeha is more appropriate or.
Yeah, so this one, we've written, the other one, I don't know who wrote it.
I may seek some clarification from that, but this is from the trust, is it?
Mm-hmm.
Thank you. Okay, any questions from the panel? Commissioner Aitken? No.
I might have one in a minute.
Okay.
I've just got one. I'm having real trouble with the plan online today because I can't find any of the things
I'm like,
quick enough. My question relates to issue 1 that you mentioned in your printout today, or your submission today, with that alternative wording, and you use the term tangata whenua. And given your explanation previously, which I really like, with you refer to yourself as tangata whenua when you're talking about the land, that your land, and mana whenua when you're referring to land where you don't own it but you still have an interest. So using that basis, why would you not include mana whenua in this alternate wording?
Which wording was it?
So the wording that you've got on the last page
Oh, yeah.
of your submission today. But I can't, as I say, I can't find SASM issue 1 to actually refer to see what the original was. But yeah, would you use mana whenua there as well as tangata whenua, using the analogy that you used before of the way you use those two terms?
So I say, like, protection of site values in areas of cultural and spiritual significance. And so for me, I'm not talking about land so much. I'm talking about values and beliefs, and it's the intangible things. It's the activities, it's the performance, it's the social well-being. And so that's why I think I've used tangata whenua, because those things, it doesn't matter where it is or who owns it, those things, those things you can't be taken away, by who owns the land. Does that answer your question?
Yeah, I think I get it. Yeah. Thank you.
Commissioner Beard?
it's fine. Good, Stella.
Kia ora.
So you will have heard my discussion around interested versus affected. And I pick up your point in terms of mana whenua, which I have to say, I've never heard it quite so eloquently in terms of the distinction between tangata whenua and mana whenua. So I think I'll take that to every blooming presentation I ever do going forward, because I think it sets it out so beautifully in terms of what the difference is. But I did pick up on the point that you used the word interested where you don't own the land, but you still have an interest as mana whenua. And I wondered whether you had a perspective in terms of retaining the word interested and or affected in the section that we were discussing. I can pull it up.
I'm glad you asked me because I do have an opinion on that.
Well, opinions.
Yeah, I would definitely like to see it retained. And I was thinking of, an example of how I could illustrate that. And you mentioned, something like you don't need to be living next door. And it made me think of those inter-hapu relationships that occurred between inland and coastal hapu, for example, where inland resources associated with a river or a lake were shared with the kaimona resources that a coastal hapu had. There were those relationships, that those use rights that cemented those ties between hapu. And I think it's a perfect example where, say, for example, a development is happening at a coastal community. Inland hapu may feel that they're not affected, but I would argue that they are. But then if someone else said, no, well, they're not, at least they're interested, gives them a chance to participate in that process, because it was a part of their traditional mahinga kai. Yeah.
No, I understand that. I think you're reflecting what I was really badly presenting, asking the question of putting it far better than I am at say. The retaining the word interests enables, as you say, the inland hapu to actually think, well, actually, I can ask the question, versus seeing affected where they feel like they've been excluded.
Yes, I think if anyone was wondering whether I can or I can't, seeing interested, they would say, oh yeah, I can. Yeah.
That's what I would do.
Thank you. Any other questions from the panel? Stella? No, well, thank you, Stella. We'll let you get on and hopefully you'll recover well. All right. Thank you very much for being patient with us and for your very clear submission statement. Thank you very much.
Thank you. Kia ora.
I'm just thinking about timeframes. Diane, it'd be good to have a break if we can. So, yeah, you're happy with that? Okay. Thank you.
Wait.
All right. Well, it's 10:36. If we have and Dean, I see you're sitting online, so I'm just going to be very presumptive and hope that you're flexible too in terms of your appearance this morning. So 40, or we'll resume at 11 o'clock. Okay. Thank you very much. The hearing is adjourned. Kia ora anō. Welcome again to the resumption of hearing stream 4 on the Central Hawke's Bay proposed district plan. Welcome, Diane, to the hearing with Pam at your support, by your side. Support. We're happy that you're here on both Mataweka Marae and Heretaunga Tamatea Settlement Trust separately, or like one?
Put one hat on and take that. And I'll put another hat on, and then the two hats will actually marry.
Sounds good. Sounds great. Okay, thank you. Will you, the floor is all yours.
Kia ora koutou, ko Ruahine toku maunga tapu, ko Toki rawa ko Waipawa tuku awa, ko Mataweka, tōku marae, o te kapuni, ko Diane Smith, tōku kia ora. So just probably just a little bit explanation as to why my name appears twice in the schedule. So first of all, yes, we did have a submission from Mataweka Marae, who I am representing today as actually the newly nominated chairperson for our marae just last week. So we're very excited as we have, we've got new plans for our marae, for our new generation. And Kia Taonga Tamatea Settlement Trust. So I actually am working for them over the summer period as an intern in my university studies. So I'm currently at Waikato University undertaking a Bachelor of Environmental Planning with my major with Māori and the environment. So I've just completed my third year. I've got a fourth year coming up before I graduate. So I have an internship with Kia Taonga Tamatea Settlement Trust is a good place for me to land and get some work experience in the trust. And it's a good strategic move. As being a member of the Tamatea Tai Whenua as a board member as well. So I guess if you're non-Māori, you may say we've got lots of conflicts, but for Māori it's not a conflict because we are all interrelated and everything, we work across, lots of members. Sure, that's why I appeared twice on the schedule. Just in regards to Stella and her team with the proposed district plan, we recognise that the amount of work put into the plan, and obviously the process with the wānanga with tangata whenua, and we appreciate the district council have taken that approach, that new approach, to bring tangata whenua to the table so that we could be part of this process. But as Stella had alluded to before, if we had the opportunity of engaging a bit earlier, we may be a little bit more involved. But I think that's just part of this new way of working and wanting to be partnering up and having a closer relationship with our council. And so we will eventually get there. This was a first step, and it was a good first step for us to be involved. But Stella has pointed out that the capacity and the capability of whether you're tangata whenua or mana whenua to engage when you're a volunteer is difficult, as Stella has alluded to. There's a lot of hours spent preparing hearings such as this in a voluntary position when persons such as myself that now work for the trust or the councillors or staff here are in paid positions. So there is, an inequity of trying to bring her view to the table and any other views from tangata whenua, just time constrained, and it is difficult. But that's one of the challenges that I'm sure we can work through with the council together. So just in regards to our submission for Mataweka Marae, and it's pretty short and sweet. Don't want to take up any time on it because it is simplistic. And the recommendation from Stella in the section, I think we're involved in the sections of the way report. And I do agree that there was a lack of information for one of the sites. So there is insufficient information, and I don't argue with Stella, and that is correct. And we needed to do some work, and we still do need to do some work on this site. So at this stage, I'm happy with the recommendations from Stella as what she has recommended so far. Any further things to say? I don't think there's any questions, really.
Be surprised.
We're just happy, I guess, to have the opportunity to put those into the schedule. As far as I know, they always thought it was there. But actually, it wasn't. As they do, they recorded all their talking as well. Actually, in the context of actually it. In there, it wasn't. So we can now say that we've made a submission, we've gone through the process. It's a very difficult process for whānau to understand. You have to submit into a long-term district plan. It has to go through hearing. So, these processes are extremely hard for our whānau to understand. Yes, you have people like me that come in and say, this is the process, let's do it. And I'll tell you about it at the end. And essentially, if it lands into the scheduling, they're happy. How it gets there, they don't have the capability to understand how we get this landed into where it's actually meant to be.
Do you think there's more information that could be obtained about the site? Somewhere, somehow?
Yes.
Supported.
This means I have to do more homework.
No, definitely.
But I'll probably, I'll just probably link it up a little bit. And it's subjective because, we would say, well, that's a site of significance to us. And the council is saying, well, we want more information. It's like, okay, how much more information is required? Do you want a pinpoint, want a drop point exactly on the PAR site? How much more information is required is probably what the whānau would come back and say, well, what else do they need to know? And we have been having that question discussed multiple times in terms of buffers versus, yes, what does it actually mean, and how detailed do we need to be? We've had conversations around a schedule where we're reminded to actually describe what it is and we are having those conversations. We take on board your point that whānau, they need to understand what you're asking. And we need to understand what we're asking. Yes, absolutely. I mean, that site that doesn't have so much information actually sits in Māori land, Māori owned land anyway. It sits in a whenua trust. So yeah, they were just asking, how much more information do we need? It's not. Straight and short.
Do you any more questions? Diane?
With your Mataweka Marae hat on, I'm just intrigued to know your thoughts on the tangata whenua, mana whenua discussion. Anything else to do?
Yeah, it's pretty much along the lines of what Stella said, really. Mana whenua, that's that status of, this is where we live, this is what we own, this is what is, endeared to us. And I will use the Poirere subdivision that is on the table at the moment with the council and with us, and we say us as mana whenua here in Waipawa. We would classify ourselves as tangata whenua out to the coast. We've submitted, we've submitted on behalf of our marae here on that subdivision consent out at the coast. We would not call ourselves mana whenua at the coast. We would call ourselves tangata whenua in relation to that particular coastal subdivision application. Even though we're related, clearly we are related, but this is where we live, this is what we own, this is where our marae and hapu are here based in Waipawa. And when we use the coast, there is clear that there is a hapu that sits out in the coastal area.
I know you're getting your head around that.
No, I was about to say, isn't that the opposite of what? Stella said?
Oh, sorry.
Yeah, so
Yeah.
Stella, I'm much like you, Tim was like, but that's not what you told me, and I'm like, yeah, but Stella made it sound so much nicer. But as I understood it, Stella was basically saying, tangata whenua is in respect to land that we own, it's ours and things like that. Mana whenua is where you have an interest, but you don't own the land. Whereas I've always, I think a bit like you've put, I've always said, well, I am mana whenua when I'm, that's the home fires. And so, yeah, so it's for our team, it's trying to understand.
You just confused me more.
I know. And you don't need the help, I know.
It's need to confuse you.
Is there a safer option to use? Is tangata whenua more of an umbrella one than mana whenua, or does it?
Is there a safer option to use?
Is that what Stella said when you are unsure, tangata whenua
Is what you fall back to.
Yeah.
That is probably the.
Oh, that's done.
Safer option.
Yeah.
Sorry, I'm Stella too.
That's Stella.
Oh, sorry, yes, tangata Stella.
That's what we wear at the Wānanga.
Stella.
Just the pepeha for Mataweka, have you had a chance to review that?
Yes.
Been happy?
And keeping them up on the glasses. We had the conversation about interested and affected. So picking up on the point of what you were saying about this Mataweka making a submission. Put on a home consent. How do you see yourself? Interested? Affected? Both?
Both actually, we're interested and we're affected because this inland hapu would go to the coast to fish. So we become an interested and affected party because that's where we go for kai. And when we come back inland, obviously, to come home, so both.
But I guess the next question is picking up our whanaunga who may not have a clear understanding of the RMA. If they were to look at something that said interested and affected, would the interest highlight if they should be thinking about putting a home, or would they be affected?
If it was back at you mean at a whānau level of their understanding, if they read it, they would probably look at it as interested. They wouldn't know the implications of what affected me. And if I just use my mum and her sisters, if they looked at it, they would go, yeah, I'm interested in that. They don't know how it affects them because they don't have an understanding of the RMA process. We have an understanding of unless you explained it to them and you had to sit down and explain the ramifications, but if they just looked at it.
And so if we didn't have interested in there, would we potentially lose the potential of a voice?
Yes. Because they were just going, that's not me.
I'm not living next door.
I'm not living in, that's not me. That's not me.
Questions? No, thank you very much, Tane. Is it time to swap hats?
Okay. Okay, you take that from and I'll put that.
Suit you.
So I guess just an apology from Darren. An interest of Heretaunga Tamatea Settlement Club. Darren's been in the club for a year. So he is literally still finding his feet under the table, coming from Ngāi Tahu into a newly formed trust. And obviously Heretaunga Tamatea, we're very happy to receive him because he had obviously had a lot of experience in Ngāi Tahu. And we thought, and we do, we believe that him coming here, we could, use that experience, use all his knowledge in moving the trust forward. So his absence today is not because he doesn't want to be here, it's because he has got so much work that he sent me instead. No, and I literally have only been there for a week and putting my feet under the table and quickly grabbing files, trying to find where we are with the trust, the lay of the land, where are the projects, and this is one of the first projects I'm like speed reading it, going, okay, can see what's. So his apologies, he's another meeting, isn't he? I guess that's my job to come along and do the best that we can. Obviously, Stella here, I've just sort of said to her, we will work together as closely as we possibly can to get things over the line without it moving on. Because this is a whole week of hearings for the district council. It's just a small part of but it's an important part for us, obviously. And we have many points, and unfortunately, we've got Ngā Hapu me Ngā Marae o Tamatea. Clearly, I'll put my hat back on for that as well. Because they've got various submissions inside the district plan, and not that I want to speak on behalf, but the person that was originally here, which was Liz was here in our tangata whenua sessions. She's now she's not speaking on behalf of me anymore, is she? So we don't want to leave them in limbo either. So if we can pick them up and help progress their submissions as well, clearly we would do that as the settlement trust sitting over Ngā Hapu o Tamatea. So yeah, just trying to work together so that we can progress things rather than stall it and leave unfinished business as much as we need to look at things moving and progress it. So. And there's a lot of points. There's a lot of submission points here. I'm not sure what the process is for each submission points. I take direction from you about how we managed the submission points, and view that Darren isn't here and Liz isn't here. Progress the
Well, just to chip in, we're at a point where we've got the final recommendations of the reporting planners following the one on previous hearings. And that's before all the submitters. So if there's any, ideally, if there's any points there that you still oppose, and get to in terms of recommendations, we'd be very interested to know that moving forward. There might be further matters coming out of this hearing that Stella feels needs to respond to through a written right of reply after this hearing. And then it goes into a black hole hearing panel deliberations where we look at everything in terms of what we can decide. And for the district plan, there are matters falling, as you know, outside the district plan that we have no scope to say, although we can make recommendations. That's the point where we're at the moment, is that's the final step of hearing before we squirrel ourselves away for a few months and make some. Well, ours is we're not making the decisions, we're making a recommended decision to the council later next year.
And I probably just want to the point due to Liz and Darren not being here. If there was anything that was like completely outstanding, is there another opportunity somewhere? If they were completely unhappy with something, is there somewhere in that process?
We'd have to just to respond. We'll have to know fairly soon.
Yes.
We could issue a minute just to set a direction to get that response from Darren or whoever. before the right of reply is prepared and issued. So there's a small gap there, small window, but we have to know fairly soon.
Yes, yeah, and I mean, I apologise because we don't want to drag this on. But clearly having to make with some important submissions, I probably need to get in front of them. Just to clarify, because if there was something outstanding and this wasn't here and didn't submit, didn't bring her views to the table, and it went through, it went on, and it's like, oh, hang on, I wanted to say this about.
Well, you will get the conversation we had earlier, and a number of those points draw out of HTS submissions and also comments that was made previously in the previous hearing process. So I am very mindful that it would be helpful to have some clarification. It might be helpful. Nothing else if we're going to listen to what we're talking about this morning, and that might help. So the big ones that they were talking about, some of the big ones we were talking about was similar to the ability to develop land, not only Māori land under the state of Whenua, but some of the matters and acknowledging like Waitemata and others, but there's all of them that settlement trust that there will be plans that we have afoot at a time that we need to potentially consider for change. So you're right, there are some big issues that we would like to sort of have some.
And I would say that there is outside the district plan process is likely to be an ongoing conversation about this. This is not the final thing, that this is an evolution in the process. So and possibly another plan change in the future. So there will be opportunities through that process, I'm sure.
Yes, yeah. And the fact that we are in, this new bringing to the table and having that wānanga and making us understand that this is how we contribute to a long-term district plan for whānau that is slightly the Māori and general, what even they don't understand district plans. That's our job to understand them. But the fact that we are now actively participating like we probably never have before, it's new, and who's going to speak on behalf and who's going to submit. So this process is fairly new. We will get better at it. And we know we need to get better at it. It's just this first one, it's like, okay, still learning where we fit and where did we come into the picture and how do we stay in the picture and get our aspirations set inside that plan.
One thing I'm really thinking is I hate to leave things to future plan changes if I can avoid it. Yes. So I'm just mindful that if there are key burning points that we can deal with in this, then that would be really helpful. But as Robert says, there is the potential for future plan changes later on. So it's not wilding.
If we've had questions or for either Brian or the trust, or is it appropriate then to still ask Diane and Sue like now?
Yeah, I mean, Diane, how do you feel about
as much as I can? Yeah, answer, sorry.
Well, some of them were just in the section 42 where Stella would said it would be helpful if the submitters could give more information or feeling on that, and I did highlight a couple of them. So one of them was under the Tangata Whenua section where issue 1 and 2, and it talked about the loss of Māori, M-A-U-R-I, and Te Mana o Te Wai, and they asked it may not be appropriate or necessary to reference both. And for fresh and coastal waters, and it would be helpful if feedback on those recommended amendments. So is it right or wrong, or it doesn't matter, or inappropriate to have both mentioned in those issues?
And I guess we talk the Tano Te Wai statement that is still being developed. And I would, I would say on behalf of Darren that we have not got the issuing statement. We need to clearly have an issuing statement from the trust. And that's why I guess what Stella had recommended was almost like a placeholder. I would say it was like a placeholder to put it in there when we talk about the regional policy statement. The national policy statement for freshwater being so new to all of us. Who else in their district, long-term district plans have put statements of Te Mana Te Wai in there. We could be the first that does it. I'd like to think that possibly we probably are. But what that statement is yeah, it is something that we need to work on clearly. I would like to think that it does go on this long-term district plan.
Using those two,
Modi,
yeah, together with Te Mana Te Wai?
well, I don't know if you'd insert the word Modi into it because Modi sits inside Te Mana Te Wai. If you were our Māori, that's just inherent.
Yeah.
Any living thing. So
We've kind of given some direction there, I think, on that. The other one was, I'm just going to scroll down to find it. 66. Volume. No idea.
What I think.
volume one.
Volume 1, if you want Te Mana Te Wai.
Page 66. 12.415. That was alternative words for. Just reading it. By their feedback on most alternative. So instead of just saying enable the active participation of tangata whenua in all aspects of the implementation of the plan, it actually went on to say that affect their relationship with their culture and traditions, ancestral lands, water sites, wahi tapu and other taonga. There's another section. Oh, is there another one?
It's a bit where I specifically mentioned Māori and Te Mana Te Wai, isn't it?
No, yes, I've just done that one.
Oh, you've done that one, okay, apologies.
That one was on page 60 of volume 1.
Okay, thank you.
And that's, so it was sort of, it was just taking a bit further, rather than enabling tangata whenua, enabling active participation in the plan. It went on to say a wee bit more that it affects their relationship with their culture and traditions, ancestral lands, water sites, wahi tapu and other taonga.
It's just a section 6 kind of reflection of section 6.
Oh, okay, you did ask that they gave their feedback on it. Provide their feedback on this proposed alternative word.
Oh, yeah.
So obviously there's no burning. Sorry, I only wrote down 4, so no.
Only 4.
But some of them I was just, they made sense, and other ones I just wanted to ask. Page 72. Page 72, 13.415. Papakāinga and Kaumatua housing. So not just to recognise and provide for development, but to support, and taking it wider than Papakāinga housing, Kaumatua flats and marae-based development, Māori land and whenua Māori. I didn't write myself any other notes there, so I'm not sure what I
This
was
is
going to ask.
72.
Easy.
So, ngā tapu o marae.
Technology is great when it works.
So then we're going to
lost half mine too.
13.6.1, which is the recommended amendments. Stella.
That's.
That's right.
Actually, while I'm there, what's your view on the use of dual Māori signage for all official place names? It's on the same page, what you've just been looking at, 13.6.1.
13.6.1.
Not
Oh,
just
yes,
to support the recognition and use of traditional Māori place names, but to actually the use of dual Māori signage.
Clearly, I would say. Yes.
Are our signs big enough to put some of them on?
I think we do have a new one.
Just confirm,
Big name.
because I know it's Ngā Hapua Marae. Submission point. When she says Māori land and whenua Māori. That's like, what does she mean? Because whenua Māori, I'm assuming because she's making Māori land and whenua Māori, that she's making the distinction of land owned by Māori. So it would be good to have clarification. Given, as I said, the conversation we were having this morning about utilising land that is purchased by you.
Yes.
They're the ones that I wrote down.
Right.
Yeah.
Can I just on those questions? Just turn back, so that on page 60. 1140. It's a wording thing, but it's like. Recommended to reword the issue 1. Say the loss of Māori and Manawatu Wai, particularly in relation. You were saying Māori is more part of Te Manawatu Wai, so. I'm just wondering whether that's the right way of expressing it in that issue.
I'm sorry.
60, bottom of page 60.
That's the one I took from her answer that the Manawatu Wai is there and Māori's part of it.
Just highlight it. Reference most of the amendments. Sorry, no. Stella. Feedback, is there any feedback? Any amendments?
So at the Wānanga, we didn't get down to specific, and there's been no other feedback come in.
She can see. Sent in any feedback, and it hasn't, and this is, this is, apologies, unfortunate, then that will be a follow-up for me to go back and say, here, there was some recommendations to get some feedback in. We need to get the feedback in sooner rather than later.
And I could highlight those areas if that's helpful to you.
Sure,
So
yeah,
these are the areas that I asked, if that's helpful.
I had highlighted that there were feedback
Yeah.
required, but I wasn't sure if feedback had actually been received. That was all. So it was just you highlight what hasn't been.
And happy to incorporate, assist if that's helpful.
Yes.
And I just wonder in terms of the loss of that particular one, loss of Māori and Te Manawatu, I think at the point, like you, I see Te Manawatu and Māori being a component of. Perhaps it's, you almost have to turn it around, the loss of Te Manawatu, including Māori. Including Māori, simply in relation to Christian coastal waters. Something like that, so switch it round. But I guess we could take Māori out, but there's an essence about Māori. And it is probably quite helpful in the context of this particular issue. Because it goes to, contextually the Māori of the. Yes. So perhaps just think about whether you could switch it around to better articulate the tikanga and respect for the ground. Without losing both, or the essence of both.
Yes, that's right, because I guess if a whānau member picked this district plan up and they looked at it and they wanted to, something was going on with a subdivision next to the river, they would understand what Māori meant. They probably wouldn't understand
Te Manawa
Te Manawa Te Wai
Mm.
policy statement meant, so they could pick up the Māori. But I understand that there's something going on.
My Lakota are dying in the water because of a land use beside it.
Yes, because the Māori has depleted in the river. I don't know what Te Manawa Te Wai has got to do with the Māori.
Yeah,
Wai awa.
it's a bit the same back to that interested and affected. What would a local Māori person, what would they pick up?
I'm gonna have to choose something. Stella,
Yeah,
you said?
that's easy.
With regards to the same page that we were just looking at, but the next one, issue 2. Is that did you mean to delete these? Should that second section be deleted? The end of that sentence, you've got my traditional food sources and Mahanga Kai at the start and the end. Is that? So it says a continuing loss of quality, quantity and access to Mahanga Kai and natural resources for customary use due to the introduction of weeds, pest, farm runoff, drainage works that have severely damaged traditional food sources in Mahanga Kai.
I could say damage then, but yeah.
Okay, so
It's clearer that have damaged these
no, I just didn't think it was, it's fine.
resources, maybe have damaged these resources.
And drainage works full stop. Because you've already said the continuing loss of quality, quantity and access to Mahanga Kai.
Is due to the introduction. Yeah, okay, so I can clarify that if that's helpful to you.
Thanks. Thanks,
You don't have any further questions or any further points you'd like to make?
No, I just think, I will. Stella. And she will highlight the points to me that I need to follow up. Very immediately. So that we can keep.
That's right. Or just for clarifications, we adjourn the hearing, we don't close it. Closing doesn't happen till way down the track, so we keep the door open, not necessarily a wide open door.
No.
Procedural and natural justice and things. What I haven't got my head around, but I'll do is the timeframes and what we're going to do and how we're going to instruct it in the directions, but in the meantime, if you could confer over those, particularly those points that Commissioner Taylor has raised. And what's feedback on those particular points? That would be very helpful. Yes.
Check. Timing of figuring that out with those points. It won't be a long time. frame.
No, that's right, and I understand that because we've come this far. To not need to hold this up any further, we should have been more organised, my apologies. If that's just, it's, some staff turnover happening, you're arriving in the seat, okay, let's go. So I will, that will be my priority. I'll work when I get back to the office tonight at midnight.
No, we won't be here at midnight.
Well, thank you very much for coming today and for talking to us. It's been very helpful and clarified quite a few things for us and also raised a few questions as well. So that's not available. So thank you again for that. And yes, and if you want to stay for the remainder of the hearing through lunchtime, you're more than welcome to.
Awesome, thank you everyone. Thank you.
Would you like to come up?
I have. Dana,
This is a little face. Beaming in from somewhere.
Yeah, it's Kakapo Bay, Port Underwood near Blenheim.
All right.
Oh,
Oh, my goodness.
that's right.
It was.
Just a minute, Dean, I'll just grab your statement. Okay. So thank you for your statement. We've all read it, but this is your opportunity to talk to that, and Marie too, if you want to contribute. More than welcome. It's falling down.
Maybe, Anne-Marie, if I'm not going to say much, but I'll start off and then you can add anything and then there may be questions. How about that for
Sounds good.
work? Tēnā koutou katoa. It's nice to be back virtually in the room. The statement I made was pretty brief. Basically, there was no, I didn't have anything to dispute from the recommendations of the author. Of course, acknowledging, as I think everyone in the room is acknowledging, there needs to be more work on the schedule and identifying places. But that's obviously not going to happen at this stage, but it needs to happen as a process ongoing. So given that I haven't put anything under question or not arguing any points from what has been recommended, I don't actually have anything else to say, but of course there may be some questions to me, or there may be some questions more directed at Anne-Marie. So Anne-Marie, if you want to take it from here.
I just want to Anne-Marie goes talking one. No Ngāti Kahungunu, Ngāti Awa te whanau Ngāti Awa hau. No Waimarama, I have an interest here. So I just want to sort of like talk to what Stella A said this morning around the working group that decided at the Wānanga about her and I and Brian, I think it was, to write up an introduction. Well, I got back to Pam and I just emailed Pam and I just said, okay, the two, we have mana whenua here, should be writing that introduction and not me, because I don't have mana whenua here, I have an interest. So yeah, just sort of like so yeah, for her and Brian and from this relationship, so like up the introduction. Then I thought no, it's not my place. I'll email Pam and just let you know. Not think I emailed. I think Stella was the one that emailed as well. I'm just picking up on things that were mentioned in the morning. So in terms of there could be interest and affected, I have views around that in terms of having an interest somewhere. One example is my mum who's Ngāti Awa. When I was looking at her land interest and everything, one time with her, she had quite a few land interests in Waimana. And I said, we're not Tūhoe, so how come we've got interests in Waimana? And she says, because the old people, we had land at Ohiwa, and the old people gave land to Waimana and Ohiwa, and then they gave us interest in land at Waimana. But she says, I've never you know, made my, you know, pushed in on it very much. So like, she's never sort of like. So she hasn't claimed that interest, even though it's there in the Māori Land Court that she has interest in Wainama. So that was her thing, that the old people was like to allow those pathways through from the inland hapu to go out to the coast, and the coastal hapu to go into the forest to kai and whatever it was all about. It was all about kai at that time. So we would be we'd have an interest, and we would be affected by anything happening on either side. They either we're on the inland or in the coastal area. So my area at Heritage New Zealand is Māori heritage listings. But I have been for a year now covering the archaeological authorities. So I understand where Stella Ray is coming from, because she works, she's, you know, she's studying to be an archaeologist. And so with the listings, I haven't seen, I guess there are some, but I haven't seen any listings from this area. And when I did approach a couple of people about listing different sites through Heritage New Zealand, they were of the view that Heritage New Zealand didn't have any teeth unless there was archaeology involved. And so, and that's sort of correct, but we provide acknowledgement, recognition, and a little layer of protection to waihi topic sites. When we encourage district council, we'd like to work with district councils and regional councils to schedule, you know, put them on the district planning schedule. Because the district councils have more power than what Heritage New Zealand has in terms of the listings. Our engagement with owners is not adversarial, so like we don't, I'm not sure what the list is for the district council, but we engage positively with owners, like telling them there is a site. It's really important to tangata whenua. It won't stop you doing what you're doing currently on your property, and we'd like to list it, acknowledge its importance, recognise it on behalf of the hapu and whānau of the area, and provide a certain level of protection by encouraging district councils to list to planning schedules. I haven't seen any for this year. There probably are, they might be old ones. But when we're writing up a listing too, we use GPS. So we have to get the coordinates absolutely correct. So we use GPS coordinates. We make sure the extent of the area. So it might only be like a little monument, but we need that area really positively identified, so that and if there is archaeology there, then it means that if it's modified or destroyed willingly or unknowingly, then we can take action. Yes, Heritage New Zealand can take action on that. Any destruction of that site. What else? So in terms of tangata whenua and mana whenua, Heritage New Zealand, our listing team, Māori Heritage listing team is, we don't define who mana whenua are. So if a group comes to us and say they're mana whenua and they want to list this site, then that's how we talk with them. So we acknowledge that they've identified themselves as mana whenua. We don't take it upon ourselves to as an organisation to identify who's tangata whenua. Who's mana whenua of that area.
Could I just jump in, Emery, in terms of places in the district that are listed with us being Wahitapu? There might not have been any recent ones, but in the proposed plan, Schedule 2 heritage items, if you go down the list from number 62 down to the end of the list, which is 71, they've all got their in that schedule. It's listed as Wahitapu, and it's got the New Zealand Heritage List Rārangi Kōrero number in that table as well. In the other schedule, Schedule 3, it doesn't include cross references in that way, but I think from memory, a lot of those, not all of them, but some of them will be as well. And some of them might be the same place in both schedules. We're not exactly sure where the overlaps are there, but that's a matter of for some of the further work to work out which ones should be in either schedule or both schedules. Yeah, so there is, those things are related in there.
Yeah, I think those were done like by Anthony and Susan and Brian, but since I've been there 3 years now.
Yep.
There's many listings down here. Through us anyway. So we get, you know what, we provide national recognition and acknowledgement. But at least there's archaeology present on the site. And we don't really get any teeth in terms of real protection. And that's where we rely on the district councils to sort of like they have it on their schedule, then they can provide that protection and regulation. But we and providing the right coordinates. So there's an issue with one in Hastings. Where we've got a certain extent, you know, we've got our coordinates and the Hastings District Council have a different set of coordinates for their listing. And so there's been damage done to that site, but we haven't been able to do anything. It was different. I had a different site. Nobody's been able to protect that. I think I've covered. Just plus the things that I've just mentioned in terms of it would be really good to get some alignment between the district council and Heritage New Zealand in terms of listings. Cultural sites.
Any questions from the panel?
Just want some more clarification, but some examples around these sites that are registered sort of to the depth of old past sites, yes, I get, but what at the other end, what would you, quite hard, you know, how far down would you register a site? You know, what would be the
Size.
no, not the size, but the reference, whether it was somewhere that they maybe there was ancestors camped there in the past or collected water. I'm just sort of trying to get my head around how far down would you go? I get Europars, I get Pars and Marais and all that. But what sort of other sites would you be interested in? Archaeological, that you've got evidence, I get that. But what other would be?
Oh, Waihi Tupuna sites, So one of the listings I've done, I might have mentioned it before, is the Foxton Courthouse. So the land of the Foxton Courthouse, the police station and the church and the school were gifted by a certain tupuna. So we listed, because the Historical Society couldn't list the building, Foxton Courthouse, because it was built in 1929. It wasn't a pre 1900 building. And they wanted to do some restoration work, so they listed it as a because of who owned the land, who had gifted the land, and who had, who had been in that area, and so that made them eligible to access or try and access funding. So that got listed, but it's like the extent of it was that courthouse, the police station is built on the old site, where the old site of the courthouse is, and they didn't do the church, but we did the courthouse and the police station. And really sort of like the GPS coordinates, and then you do a map of the extent and all your dots. And yeah, so that whole place been listed as a Waihi.
So just to go more, not so much Heritage New Zealand, but just any site that could be listed. So say an area that was used for collecting food where they camped, that would be a site you'd register. Sort of just trying to get my mind around as a landowner. What sort of area would I want to be concerned about if I found something that might be referenced that needed to be registered, or at least go to relevant authorities to talk about?
I think so one listing I've done in my here, I might have talked about that one thing, but it was a site where the women had their mokokawai done, and then would go and sit on the rock and look at the reflection in the pool of water below, and then use the there was certain type of reeds and things like that were there. Use those to bathe there. Bathe there, in mokokawai. So when we listed it, I negotiated with the owner, but it was a forestry company, and I went through the forestry company till I found the real owner who lived in Guernsey, thing, and made contact with him, and he was really amazed. He said, "Yep, I'm fully in support of that." So he allowed a certain, quite a bit. I said, "We just want to do the rock and the pool of water and a little bit of a parking area around it." He goes, "No, you can have that whole side. That whole side, you can have that." And because it's so close to a main road, it's a public road. He just said it's fine. Just have that piece, and he extended it. So I had to do the redo all the coordinates because he wasn't using it for anything, and it was right alongside the river, so it flooded quite often. So it did, couldn't thing, and he was changing to forestry out there. A bit further along, a bit further back from the river.
Because one of my concerns is that I'm just saying as a landowner, and any landowner could be, is that when we buy a block of land, or we decide to do something with it, say I go and buy a block of land thinking that I want to develop it, and we don't have these registered sites, and we talk about it in the plan and how we go forward with them, is how do we protect those people that when they go there and buy that land and they do their research, but then someone comes along and says, "Oh, sorry, there's a site on that, you can't do anything because it's not registered." I'm just trying to get my head around how we protect both parties.
Yeah, I suppose nobody knows really where where things are, you know, like until somebody discovers it. And so I think part of our role is to educate landowners to get an archaeological authority or an archaeologist just to do an assessment on their land to see if there is anything. And then what you can do to mitigate disturbance, because you don't want to if there's like an on-pass site or a burial ground or something like that, you don't want to disturb the thing, but you might want to just put a fence around so that the stock and that don't get in on it. And let people know that, like there's all different ways that you can just negotiate how you want it. How you want it done. If you're the landowner, whether you agree to having it listed. Oh no, you're gonna like that one in Mahia. Whānau were really keen to write up articles and things like that, so that's what they did when it was done. And then in the summertime, like you go to the site and it's like 250 people. Because they'd read about it.
That's good or bad?
Oh, well, there were so many people on the site that it was, about rubbish and toilets and all that sort of thing. And all swimming and all trying to swim in the. And that was a positive one because even though blood was shed, that was a positive. Quite a positive story for even the forestry. And plus they've got agreements with whānau, like there's burial grounds within the forestry, some ancient ones that they've identified and fenced off. They're taking trees out so that they can look after the site.
It's more, I was just thinking more around if again, a landowner buys a site and wants to put a factory on it, for example.
What?
A factory, for example, on it, and then someone comes along and says, well, actually, there's a tapu site on that, but it hasn't been registered in the council. That's where I'm trying to make sure that both parties are protected going forward. And, I get the ones where you start digging, putting foundations in, you suddenly find the site and you go, well, okay, well, I found one and by law, you've got to do what you've got to do, but it's more about that person. Maybe someone decides they don't want that factory there and then they use that as an excuse. And I'm not saying that will happen, but I'm just trying to protect both parties.
Yeah, I think that's when you get an archaeologist, just to come and have a look. See whether they can see anything on top of the ground and how you can avoid it. And it depends what you find, whether it's like a power site, will be, like gardens and pits, kumara pits and pits and things might be around, but just have to.
Been talking about an archaeologist doing an assessment. It's not always a big whole report they need to do. An archaeologist would look at the surrounding area and what they know of the history of a place. And in some situations, they'll just write even an email and saying it's unlikely you're going to find anything. I think the risk of finding anything is very low, and you can go ahead without needing an authority. In other cases, they might say, even though there's nothing listed or registered or scheduled here, there are places in close proximity and it's likely that this was used. So you really need to apply for an authority so that legally you're covered and you're not going to damage an archaeological site without the proper authority in place.
Further questions? Okay, we have no further questions. Dean and Andy, thank you for your attendance.
Okay, thank you very much.
Thank you. I know you've got speaking notes. If you feel they're good enough to share with Jessie for our record, would you be so kind to do that? If they're too rough and ready like mine, I understand.
Really.
Well, thank you very much. Thank you again, Diane, and thank you again, Anne-Marie and Dean. We'll adjourn the hearing for lunch. And after lunch, we're due to have Stella just respond to any matters arising and we'll take it from there. Thank you. Thank you. Good afternoon, everybody. We will resume hearing stream 4. We are up to the point where we will turn to the reporting planners to seek their immediate responses to matters arising today. And beyond that, we will look towards getting deadlines for rights of reply, written rights of reply. So no further ado, I will Stella and ask her if she's got any immediate responses arising from today.
Just really got some comments and clarifications. So just that there's a number of actions out of play for me. One is that I will prepare and send a spreadsheet with the submissions that we're wanting feedback, well, that I had suggested we get feedback on. I'll send that to Di Smith at Heretaunga Tamatea Settlement Trust. And in terms of, and I'll talk about that in a little bit. There's still some bits and pieces coming in relation to that chapter 1. That first chapter, particularly, I think, around the pepeha. I think maybe we'll have a little bit more of a discussion around whether we're going to see any amended provisions to the SASM introduction or not at this stage. So we will come back to you on that. And I've been listening with interest to the discussion about I have been listening to that conversation and I'll come back to you on that. I would ask that we could have an extension to the right of reply beyond the 10 working days, and I'm tentatively at the moment thinking Friday the 9th of December, but I have had a quick discussion with Di Smith about what time they need to be able to address those matters. So she's going to come back to us early next week with a date that's going to work with them, being very mindful of that we are under some quite tight time pressures. And that's just to enable her to be able to work out the process they need to do to get the feedback from the feedback in the best way possible. So once we have that, I'll send that on to Jessie or to you. Probably the only other thing I wanted to comment on was I found that conversation or the presentation from Anne-Marie on the SASM sites really, really helpful. I hadn't particularly realised that the Wāhi Tapu sites that they have registered are not necessarily always archaeological sites. So that would kind of indicate that you would want those sites on the SASM schedule. However, I still think I think that we're not at the stage to mess around with those schedules until there's been engagement with Tangata Whenua. So I would still see that sitting as that further piece of work. But it's a helpful, I think it'll be one of the parts of the conversation that'll be a really helpful starting place. And I think some of the other actions are really going to be in response to when stuff comes back in from Nahapu and Heretaunga Tamatea Settlement Trust. So those are all my comments I had.
Thank you.
Happy to answer any questions.
I know Commissioner Lovell has a question around the schedule of questions. Not the questions, the table that you are of matters outstanding that were subject to finishing of this hearing. We were discussing over lunch that it might need to be a bit wider than just Tangata Whenua submitters on thing. There were some outstanding matters through the course of right from hearing one, I think, where it was subject to the outcome of the tangata whenua hearings.
So, okay.
So other
We're mixing
authors
tables. We're not talking about the one that you're giving to Di.
to die.
We're talking about the.
Yeah,
table
yeah,
you
yeah,
said
I understand that. Yeah,
And that's- some of those matters,
Yeah,
some of those matters had other authors that were involved in
Yes.
things. So,
Or luckily sit in the same office.
yeah.
so are you saying some of those weren't necessarily submissions from tangata whenua?
No, they were related to tangata whenua, or they were tangata whenua matters. But what we just want to ensure, he might have, yeah.
So they'd be like Federation Farmers or someone like.
No, it's just, for example, you might have been the writer. Your commentary was you will be
Absolutely.
considering your point, so we just need the crossover, which is.
Oh, absolutely,
Say,
yeah,
I've said
yes,
that I've changed
Yes,
my
yes,
recommendation
yes.
proposed to.
yes, okay, sorry, I'm with you now,
Yeah.
with you now.
Just so that we
We
know
will
that we are
look at,
covering it all from both.
So what I'm envisaging is that I have gone through all the topic reports and picked up any submissions from tangata whenua. And then regardless of who's written the report or the recommendation, we will coming back to you saying we've looked at it and haven't changed our mind, or if we have, this is the reasons why.
Yeah.
Okay,
Did you just say only submitted by tangata whenua
yes.
or on tangata whenua issues? So your comment about fed farmers would be correct, because if it was
Yeah, there are questions where, for example, fed farmers might have said, we want this, and the report writer said, we don't have enough information on that, you may need to ask. I'm not sure if there are examples.
I don't know how many of those there are,
We'll
but
look at that.
Double
we'll
check.
double check, yeah.
was one of those niggling at the back of my head, but I
Yeah.
can't quite grab the file.
While you're doing that, we also discussed over lunch timeframes, because we indicated before the window is very narrow at the moment, because our last hearing, as you know, is 4 weeks away, and then we'll go into deliberations. So we have a very narrow window to get any further, and we need the right of reply to have addressed anything that any information that comes out of today or after today, I should say. So
So could I give you a right of reply on all the other matters? And then, like I could have the table prepared for you by the 9th. I could have, if there's any other matters that come out of your directions, I could respond to those. And then we could see whether the feedback from submitters is going to fit with that, or whether it needs a little bit more time.
And I suggest that first and foremost, the preference would be to have a whole right of reply. If possible, so in terms of the timeframe.
we were discussing a potential extension of the right of reply from anyway,
Yes.
but a little bit concerned that our extension wasn't quite as long as the one you just indicated. It's a shorter time frame. So another, like a week.
I think we just need.
Yeah, well, it depends.
We were asking for about 79 days.
Yeah, no, in terms of getting those questions to the trust and getting a reply back in time for you to incorporate into your right of reply.
For you to give me direction.
Yes, and squeeze that in there somewhere.
3 weeks we're asking.
We're asking for 3 weeks,
Right.
3 and just over 3 weeks, which is that Friday of the next hearing,
So I'm just thinking if you can,
or earlier.
what's the sort of latest time frame? If you were to stick to having one right of reply, what's the latest time frame you could have to get the feedback on that one aspect on those outstanding questions?
Well, that's really where I feel like I need some feedback from Di around that. Yeah.
It's Di, what we're saying is the window is limited. And whatever was agreed in terms of right of reply, that's got to be.
Yes.
Sooner rather than later.
Yes, and just obviously the more we talked about it and sort of figuring a way forward, knowing what we know now, So I just sort of said to Pam, not that we want to make work, but if we had taken the points out of those huge documents and succinctly sent them direct, we might have got a better, quicker, faster response. And what we've, discussed is that we will extract it out really fast and go straight into Darren and Liz and say, we need some immediate feedback, rather than looking at the whole entire document, again, so that we can, fast track it as fast as we can get there. Knowing that, yes, we don't want to hold this process up. And we will, work fast on it as fast as we can.
So when do you think you'll be able to go back and give us a time frame to be able to do this? No.
I would say if Stella could extract, what's required, because there were some statements still required from HTST, from Darren especially. If faster I get that, then I can, approach Darren and find Liz.
So I should be able to do that on Wednesday. I'm here tomorrow, but then Wednesday's a day, non-hearing day for us anyway. Not really good. Okay.
Probably want to get this out to Friday.
So, yeah.
Friday.
Okay, so you'll get mid to late week. We need to issue a minute, that's and so if Stella gets it to you mid to late week, can you come back to us on Monday with a timetable?
Yes, yeah, I should be able to get to talk to Darren. Yeah.
Preferably put it under his nose and say yes, no, sideways. But aside from that, we need to issue a minute, so we need very, very clear. And we've got a range of matters that we can consider when we're determining these as part of the full process.
The only other point I would raise at this point is around the PPH. So it's clear that not the PPH haven't all been signed off by the relevant MRI at the moment. So if you could provide us with some advice around that, where we're getting to with that. Because that's what we would be seeking, is to have that authorised by the relevant MRI to go into the plan.
And I think we're pretty close to that, aren't we, Pam?
Cool. Okay. Fantastic. Any other questions for Stan? Okay, well, thank you. With that, we'll adjourn a hearing on hearing stream 4. And we'll issue a minute fairly soon, hopefully this week. And get those instructions, and the 9th of December, I think we'll be working to. It's just one quick question. Are you involved with hearing stream 7? Last one?
Oh, very minor. But we, I can't imagine there'll be too many.
Yeah, thanks.
Who knows? Might be the one that. The big one we're all waiting for.
Okay, well, thank you very much, everybody, for your efforts and hard work. And with that, I will go on to 4.